Members, I think those are all the housekeeping items. And with that said, any member seek recognition to debate the bill? Senator Crouch, ladies recognized.
Thank you, Mr. Chairman. Good morning, everyone. I'm going to make some brief comments, and then staff is going to walk us through the bill. It's very complex. Care for Women, Children, and Families Act, the title says it all. That is exactly what it does. This is mainstream, common sense legislation. You're going to hear from some that it's extreme. Emails went out last night saying we were banning abortion. Totally untrue. I hope you will listen to the bill as it's explained by staff. I hope you will read the bill and you will see that none of that is true. It truly is mainstream. Polls show that 57% of North Carolinians are exactly where this bill puts us on the abortion spectrum. Not only is that how North Carolinians feel, but it's mainstream around the world. 184 of 198 countries and territories, that's 93%, limit elective abortions after the first trimester, or they do not permit elective abortions at all. That's pretty mainstream. Since the Supreme Court handed down the Dobbs decision, many of us who have worked for decades to save babies' lives, some I see in this room that I've worked diligently with, and thank you all for all of that work. We saw it as an opportunity to put forth legislation that's pro-life and pro-woman. Most women say when you ask them they would prefer to keep their babies if their situation were different. Well, now is going to be different. This bill has opportunities that will enable women to be empowered to make their own decisions and not feel pressured by others to make a decision that they would not make otherwise. This bill includes $160 million for women and children's needs. Many of these opportunities for moms in this bill will make it easier for her to make that decision to keep her baby. Babies are not burdens. They are a joy. They are a gift. Tremendous strides have been made in the medical community since Roe was enacted. Babies are now able to survive much earlier than we ever dreamed possible when we first started this journey. This bill is the right thing to do for women, for children, and for their families. And Mr. Chairman, I ask that you have staff walk through the provisions of the bill.
Which members of staff are handling this bill? Gentleman's recognized.
Jason Moran Bates, Legislative Analysis. Part 1 of the Conference Committee substitute to Senate Bill 20 is abortion law revisions. Page 1, line 7 of the bill, you'll see that the current abortion law in Chapter 14, Section 45.1 is repealed. There are a bunch of reporting requirements in that section that are going to be recodified in Chapter 90. Page 1, line 8, the current Woman's Right to Know Act is going to be retitled Abortion Laws. Most of the portions of the act will remain, but there will be new provisions added. Page 1, line 14 through page 4, line 1 amends the definition section of the new Abortion Laws Act. There will be a new definition created for medical abortion. The current definition for abortion is going to be redefined as surgical abortion. The definition for medical emergency will remain the same. There is a definition added for life-limiting anomaly, and that is the diagnosis by a qualified physician of a physical or genetic condition that, 1, is defined as a life-limiting disorder by current medical evidence, and 2, is uniformly diagnosable. If you turn over onto page 4, lines 12 through 17, you'll see that abortion is legal for any reason for the first 12 weeks of pregnancy. Page 4, lines 18 through 21, abortion is lawful through the 20th week of pregnancy if the pregnancy is a result of rape or incest. Page 4, lines 22 to 23, lawful through the first 24 weeks of pregnancy if there's a life-limiting fetal anomaly. Page 4, line 11, abortion will be lawful at any time if a physician determines there is a medical emergency. This definition is not changed. Medical emergency is a condition which, in reasonable medical judgment, so complicates the medical condition of the pregnant woman as to necessitate the immediate abortion of her pregnancy to avert her death, or for which a delay will create risk of serious or substantial and irreversible physical impairment of a major bodily function, not including any psychological or emotional conditions. Page 4, lines 25 through page 5, line 24 lists the reporting requirements for physicians, the provisions allowing physicians to object to performing abortions, and clinic inspection requirements. These are the old provisions from GS 1445.1 that are being recodified. That's largely unchanged. In order to perform an abortion legally, all abortions will have specific informed consent provisions. These are mostly based on the current informed consent provisions of the Woman's Right to Know Act. Page 5, line 25 through page 6, line 28 sets out the informed consent provisions for performing an abortion when there is a life-limiting anomaly. In addition to following the informed consent provisions for medical and surgical abortions, which I'll get to later, if there's an abortion for a life-limiting anomaly, the informed consent provisions include a statement for the basis of the life-limiting anomaly diagnosis, the risk associated with the anomaly and any forms of treatment, a statement that life-limiting anomalies have resulted in the births of live infants with variable lengths of life. Current information must be provided on the likelihood of survival of the anomaly. Referrals for neonatal and palliative care consultations must be included, and information on the continuation of pregnancy. In the case of the life-limiting anomaly abortion, the physician performing the abortion must also report to DHHS. This is page 6, lines 16 through 25. On the identification of the physician who diagnosed the anomaly, the identity of the physician who performed the abortion, the probable gestational age of the child, the pregnant woman's age and race, and her pregnancy history. Page 6, line 29 through page 9, line 37 are the informed consent provisions for surgical abortions. These are mostly taken from existing law in the Woman's Right to Know Act. In order for there to be informed consent for a surgical abortion, the woman undergoing the abortion must be given a consent form that is going to be developed by DHHS at least 72 hours prior to the procedure. The form must be signed and initialed by the woman undergoing the abortion and the physician providing it. The form must include identification of the physician providing the abortion, the risks of both the procedure and of carrying the pregnancy to term, the probable gestational age of the unborn child, a display of the real-time view of the unborn child, a statement whether the physician has liability insurance, a location of the hospital where the woman may be admitted if there are complications. In addition to this, the woman must also sign a statement of risks at least 72 hours prior to the procedure. This is page 8, line 9 through page 9, line 18. Many of these provisions are in existing law, and they include information on the benefits that may be available for prenatal care, childbirth, and neonatal care, information on public assistance programs, a statement that the father is liable to assist in supporting the child, a statement that there are alternatives to abortion and that there are DHHS-sponsored materials on some of these programs, and a statement that the woman is not being coerced into the abortion. Those provisions are all found in existing law. The new provisions are an attestation that the woman understands the abortion is intended to end her pregnancy, an attestation the woman has been given an opportunity to ask questions about her pregnancy, the development of the unborn child, and alternatives to abortion, a confirmation the woman received the state-prepared materials on abortion, an attestation the woman has been given sufficient information to consent to the procedure, a statement the woman has a private right of action against a physician who coerces her into an abortion, and a statement that the woman has been given printed copies of all informational materials in consent form. The final element of informed consent for the surgical abortion is that the physician must sign a declaration that the abortion procedure has been explained to the woman, that she's been provided all the required information, and that all of her questions have been answered. Page 9, line 38 through page 10, line 34. These are requirements for printed materials from DHHS. It's mostly current law. The one new provision is page 10, lines 28 to 30, directing DHHS to develop the informed consent forms. Page 10, line 35 through page 13, line 36 are the informed consent procedures for medical abortions. For the most part, they parallel the provisions for surgical abortions. In any medical abortion, the physician prescribing or dispensing the abortion-inducing drug must be physically present when it is first administered. That requirement is page 10, lines 47 through 50. In order for consent to a medical abortion to be informed, the woman undergoing the procedure must be given a consent form developed by DHHS at least 72 hours prior to the procedure. That form must be signed and initialed by the woman undergoing the abortion and the physician providing it. And the requirements for that informed consent form are page 10, line 42 through page 12, line 9. They are the same elements as required for informed consent for surgical abortion, with the additions of a description of the steps necessary to complete the medical abortion. Information on RH factor incompatibility must be provided, and the woman must be given notice that she may see the remains of her unborn child. In addition to this, the woman must also sign a statement of risks at least 72 hours prior to the medical abortion. That statement must include the same information required in the surgical abortion risk statement. The particulars are page 12, line 27 through page 13, line 29. Then turning to page 13, lines 32 to 36, the physician must sign a declaration that the medical abortion procedure has been explained to the woman. She's been provided all the required information, and all of her questions have been answered. Physicians performing medical abortions do have some additional things they must do. This is page 13, line 37 through page 14, line 18. The physician must verify the pregnancy exists, determine the woman's blood type, and offer necessary medical services based on that information, as well as provide any medically necessary diagnostic tests. The physician must screen the woman for abuse and refer her if appropriate. The physician must inform the woman she may see the remains of her unborn child. The physician must verify that the probable gestational age of the child is no more than 70 days. All findings must be documented, and the woman must be scheduled for a follow-up visit to take place sometime in the next 7 to 14 days. Page 14, lines 19 through 25 specifies information that must be provided to the pregnant woman before abortion. Most of these provisions are already in the informed consent provisions. If you look at page 14, line 26 through page 17, line 20, most of this is all current law. The only substantive changes are a provision on page 15, lines 15 through 17, that abortion clinic policy cannot prevent a woman from having a right to a real-time view of the unborn child. Provision on page 16, lines 4 to 10, to clarify that a woman who had an abortion performed on her in violation of the provisions of this article, or her parents, if she were a minor at the time, have a private right of action against the physician who provided the abortion. And on page 16, lines 23 to 30, clarification that a physician or other healthcare provider who violates this article may be disciplined by the appropriate licensing board. Page 17, line 21 through page 19, line 17, physicians have to report to DHHS on all abortions performed after 12 weeks of pregnancy. In addition, the following information is needed for all abortions, regardless of when they're provided. This is page 17, line 38 through page 18, line 19. Identifying information of the physician performing the abortion, the location of the abortion, demographic and medical history information of the woman who had the abortion, the probable gestational age of the unborn child and the method used to determine that age, information on any follow-up appointments, and information on any complications to the abortion. Page 18, lines 20 to 44, requires all adverse events from an abortion to be reported. The report must go to the FDA if it's a medical abortion, or to DHHS if it's a surgical abortion. These reports must include all the information required for a normal abortion report, as well as the date of treatment for the adverse event, the specific medical complaint, and in the case of a medical abortion, if the woman got her abortion-inducing medication via mail order. Page 19, lines 18 to 48 would create a new criminal offense for any individual or entity sending abortion-inducing drugs to a woman if those drugs are not used in the physical presence of a physician as required by the medical abortion statutes. Also, advertising abortion-inducing drugs for the sole purpose of their being used by a pregnant woman outside the physical presence of a physician would be a criminal offense. Both of these offenses would be infractions punishable by a $5,000 fine. Page 20, lines 4 through 14 would amend the current ban on sex-selective abortions to also prohibit abortion based on the presumed race or presumed presence of Down syndrome in the unborn child. And there would be conforming changes made throughout Article 1I of Chapter 90. Part 1 would be effective July 1st, 2023. Part 2 is suitable facilities for the performance of surgical abortions. This is page 20, line 36 through page 23, line 39. Page 20, line 40 through page 25, line 5 specifies that for the first 12 weeks of pregnancy, surgical abortions may be performed in a hospital, an ambulatory surgical center, or a licensed abortion clinic. After 12 weeks, surgical abortions must be performed in a hospital. Page 21, line 4 through page 23, line 38 sets up regulations to license abortion clinics. These regulations are based on the current existing statutory law for ambulatory surgical centers. DHHS and the Medical Care Commission would be required to adopt rules to administer these statutes. Those rules can be no more restrictive than the rules that currently exist for ambulatory surgical centers. No one can operate a clinic without a license. That fee would be $850 plus $75 per operating room per year. Operating a clinic without a license is a Class 3 misdemeanor, punishable by $50 for the first offense and up to a $500 fine for subsequent offenses. DHHS has the authority to enforce the rules, inspect facilities, and seek injunctive relief against those who don't comply with the requirements. The portions of this part requiring DHHS to develop rules would be effective July 1st, 2023. The remainder of that part would be effective October 1st of 2023. Part 3 is the Born Alive Abortion Survivors Protection, and this is going to be page 23, line 40 through page 25, line 16. Page 24, lines 14 through 24 would require healthcare providers to exercise the same degree of care for an infant born alive after an abortion attempt that they would for any other child born alive at the same gestational age, and to ensure that infants born alive after an abortion attempt are immediately transported to a hospital. Page 24, lines 25 through 29, any practitioner who had the knowledge that another healthcare practitioner did not do either of those things would be required to report it to the appropriate law enforcement agency. Page 24, lines 35 to 51, providers who fail to exercise the degree of care or to report would be charged with a Class D felony, including a fine of up to $250,000, as well as being civilly liable to the mother of the infant. Page 25, lines 9 through 10, clarify the murder statutes, amend the murder statutes to clarify that an intentional overt act that resulted in the death of a child who was born alive would be considered murder. This part would be effective July 1st of 2023. Part 4 is reforms to reduce infant and maternal mortality and morbidity and to increase access to contraceptives. Part 4 is page 25, line 18 through page 30, line 45. Section 1 of Part 4 appropriates $3.5 million in recurring funds for each year of the biennium to award competitive grants to local health departments and nonprofit community health centers to make long-lasting contraceptives available to underserved, uninsured, or medically indigent patients. In order to be eligible for the grant, the contraceptive must be effective for a period of time without user action, able to be discontinued, approved by the FDA, and available via prescription. Page 25, line 37 through page 26, line 5 would increase the Medicaid rate for obstetrics maternal bundle payments for pregnancy to at least 71% of the Medicare rate. $2.8 million in recurring funds for each year of the biennium would be appropriated for this purpose, providing a state match to the $5.5 million in recurring federal funds. The Division of Health Benefits would be required to include add-on amounts to the current capitated rates for prenatal care services to incentivize providers to participate in that program. Page 26, line 6 through page 30, line 36. This is section 4.3. It expands the scope of practice for certified nurse midwives. Page 26, line 24 through 28, CNMs would be able to write prescriptions under rules adopted by the Medical Board and the Board of Nursing. Page 28, lines 24 through 34, CNMs with less than 24 months and 4,000 hours of practice experience would have to have a collaborative practice agreement with a physician or another certified nurse midwife who has at least 4 years and 8,000 hours of experience. Page 28, lines 38 through 50, CNMs who attend births in a non-hospital setting must have their patients and signed an informed consent agreement. That agreement would be developed jointly by the Medical Board and the Board of Nursing, and it must include information about the risks of non-hospital births, a statement that the patient assumes those risks, and an agreement that the patient will be transferred to a hospital if the nurse midwife deems it necessary. The CNM would also have to make a statement whether or not the individual has malpractice insurance. Page 29, lines 1 through 16, home births attended by a CNM have to include a written plan for emergency and non-emergency transfers to a hospital. Page 29, lines 43 to 46, CNMs with more than 24 months and 4,000 hours of practice experience would be able to practice on their own without a collaborative practice agreement. Page 30, lines 12 through 35 would make healthcare providers treating patients in emergent situations that rose because of the actions of a CNM in a non-hospital setting immune from liability in many cases. There would be conforming changes made throughout. This section, the nurse midwife section, would be effective October 1st of 2023. And then finally, on page 30, lines 37 to 45, there would be an appropriation of $250,000 in non-recurring funds for each year of the biennium to fund expansion of the Safe Sleep North Carolina program. Part 5, starting on page 30, line 47, is parental leave for state employees. Page 31, lines 7 through 11, direct the State Human Resources Commission to adopt policies giving state employees 8 weeks of paid leave after giving birth and 4 weeks of paid leave after becoming a father or adopting, fostering, or otherwise placing a child. Part-time employees would be entitled to the same leave policy with prorated amount of leave. The leave would be available without exhausting other paid leave. It doesn't have any cash value. On employment termination, it cannot be used to calculate retirement benefits. Page 31, lines 46 to 49, appropriate $10 million in recurring funds for each year of the biennium to DPI to fund this leave for teachers. And there will be a bunch of conforming changes made throughout this part as well, and this part would be effective July 1st of 2023. Part 6, child permanency, safe surrender of infants, foster care, adoption, and support for new mothers, page 32, line 2 through page 43, line 17. Section 1 appropriates $700,000 recurring for each year of the biennium to the State Maternity Home Fund. Page 32, lines 17 to 25, section 6.2 establishes provisions for the safe surrender of infants. All of these provisions were in the original Senate Bill 20, which passed both chambers. The only major change is that the provisions would apply to infants 30 days or younger. The original Senate Bill 20 applied to infants 7 days or younger. And these will only apply if the infant has not been abused and it's surrendered by a parent who does not intend to return. Infants could be surrendered to healthcare providers, first responders, social service workers who are on duty at the time of surrender. The individual who takes the infant into custody has to protect the infant's well-being and notify DSSS, but will be immune from liability except in cases of gross negligence, wanton conduct, or intentional wrongdoing. Parental information is going to be confidential unless the parent agrees to release that information. Once the infant has been surrendered, the DSS director takes custody of the child and has the parent's legal rights without going through the court process. If a non-surrendering parent is identified, the director must place the custody of the infant with the non-surrendering parent. Within 14 days from the date of the surrender, the DSS director must place notice in a publication that the infant has been surrendered. Page 35, line 44 through page 36, line 7, the surrendering parent has the right to request custody back of the infant. If that happens, the case is going to be treated as one of neglect. The surrendering parent can also relinquish parental rights for adoption, and the surrendering parent is immune from civil and criminal liability as long as there was no abuse prior to the surrender. DHS has to create information on the safe surrender process and publish it to people who might receive surrendered infants. And the court process within 10 days from the filing of the date of the petition to terminate parental rights for the next term of court. They have to conduct a preliminary hearing to address the infant's safe surrender. There are a bunch of conforming changes made as well. A new section, page 41, line 43 through page 42, line 4, would prohibit delaying or denying adoption or foster placement on the basis of race, color, or national origin. Section 6.6 would allow relatives providing foster care to children to obtain reimbursement for that foster care without first getting licensed. $5 million each year recurring would be appropriated to fund this program. The reimbursement rates would be $350 per month per child for children birth through 5 years old, $371 per month for 6 through 12, $405 per month for 13 through 17. Section 6.7 increases the maximum rates for participation in the foster care assistance program and appropriates $10 million in recurring funds for each year to implement those rate increases. Section 6.8 appropriates a little over $1.7 million in recurring funds for each year to provide the state portion of the total cost of care to implement an increase to the administrative rate for foster care and adoption assistance. Section 6.9 appropriates $11.8 million in non-recurring funds for the 23-24 fiscal year to provide additional funding to cover a loss in federal receipts from the Family First Prevention Services Act regarding congregate foster care. Section 6.10 appropriates 1.5 recurring in each year to the North Carolina Community College System to allocate to the NC Finish Line Grants Program. This part would be effective July 1st of 2023. Part 7, expanding access to childcare. Funding for 3, 4, and 5-star childcare facilities at the 75th percentile of the 2018 childcare market study rate would be in effect through September 30th of 2023. Beginning October 1st of 2023, that reimbursement would be at the 75th percentile of the 2021 childcare market rate study. $32 million in recurring funds for the 23-24 fiscal year, and $43 million in recurring funds for the 24-25 fiscal year are going to be appropriated for that purpose. Part 7 also would amend the reimbursement rates for childcare tuition of low-income children in private childcare so that the tuition will be reimbursed at either the 1-star rate or the rate actually charged, regardless of which is lower. Part 8 expands satellite-based monitoring for violent and repeat sexual offenders, increases the punishment for assault on a pregnant woman, and establishes the crime of misdemeanor domestic violence. This would change the rules for satellite-based monitoring so that individuals who are reoffenders of more serious sexual crimes could be placed on satellite-based monitoring for life. Individuals who are reoffenders of less serious sexual crimes could be placed on satellite-based monitoring for 50 years. In either case, the existing judicial process for approving the monitoring has to be filed. Would also create a specific crime for assault on a pregnant woman and for misdemeanor domestic violence. Finally, at the end, we have parts 9 through 13, some miscellaneous provisions. Part 9 of the conference committee substitute suspends the order of appropriation bills in Chapter 143C as it pertains to this bill. Part 10 specifies that nothing in the bill would create a right to an abortion or make an abortion lawful if it were otherwise unlawful. Part 11 directs the reviser of statutes to ensure that all new definitions are in alphabetical order and numbered correctly. Part 12 is a severability clause, and Part 13 makes the bill effective when it becomes law unless otherwise provided.
Okay, members, the chair is not sure what else there could be said at this point, but do any members seek recognition to debate the bill? Members, before we get into that, the chair does see that we have a number of pages who are with us today who should have been recognized at the beginning, so the chair will go ahead and do that. If you will stand when your name is called. Gracie Cohen with Senator Berger. Anna Danforth, also with Senator Berger. Virginia Pope, Senator Bergen, and Ainsley Rash with Senator Galey. Thank you all for being with us today. Okay, members, we're going to move to debate. Representative Reeves, gentleman's recognized.
Thank you, Mr. Chair. I had a question or two for staff, if that's permissible.
Yeah, gentleman may ask his question to staff.
All right, thank you. And for whoever can answer this, we had sought to try to put forth some amendments. Are we allowed to put any amendments forth on this bill?
And the chair will take that question. As the gentleman knows, this is a conference report which we can't amend in this committee.
All right. Then my next question would be for chair or staff. With the process of a conference report, is there anybody that can explain what that is for those of us who haven't been here and for some of our new members so that they'll understand what this procedure will be?
Well, and as the gentleman knows, and I think all the members of this committee know by now, being that this is a joint rules committee generally made up of senior members of both parties, as the gentleman knows, it is where a conference committee is appointed and those members get together, talk to different folks, and they come to an agreement, sign a report, and that's where we're at today.
All right. Then if I may be recognized to debate.
Gentleman's recognized to debate the bill.
What I would say is this, is that I think it's a fair interpretation to say that the bill that was sent forth for conference is not the bill that we see before us today. I would say personally that this is that was the longest summary of a bill that I've had a chance to experience since I've been here 9 years, outside of course, budget bills. And that's fair. It's a comprehensive bill. It's a very complicated subject. What I struggle with is the process that brings us here. And what I think we can fairly say for a lot of people in this state, this is probably the most controversial issue that we'll be dealing with this session, even beyond the budget. And this bill, which I think is about 46 pages, gets dropped in one night in a conference report. We're here for the first joint rules session that I've been a part of. And I just don't believe that this is how democracy should work. I think that it may be a tiresome thing to hear from me, and I know I've talked about this before, but I believe that with a deliberative body, you have deliberations. I think rules is the final stop that we ought to have on any of our bills, but definitely should not be the first stop for a bill of any kind, but especially this magnitude. I am very uncomfortable with looking through this bill and seeing the wide range of subjects that are affected with this bill, knowing that, at least to my knowledge, not even half of this body was consulted about how to do this, how to proceed, and what the effects are. For as many times as I, as an attorney, have heard the attorney jokes about legalese and things of that sort, the problem that I have on this bill is that this affects the rights of over half the population of this state, and it's being treated as a one-off when you've got to read it in place with all the other bills that we've passed over the last 10 years that affect this issue. It is an incredibly personal issue. I see points in this bill, for instance, that discuss rape, that give us no discussion about how those exceptions are played out. As a prosecutor, I know how sensitive that subject can be, how many issues that you can have with people who are trying to avoid the criminal process but have been unfortunately put in a horrible situation. I know that this is more than whether or not a woman wants to make a decision about having a child, not having a child. I know of all the health issues that come along with this subject. And so what I would say is, again, whatever you feel about the subject, whatever your position is on it, I believe strongly that a wide swath of people should be talked to. This bill should be the most deliberated of any of the bills that we do. And this should have been something that should have gone through a full committee process in both chambers with full discussion, instead of people scrambling last night and scrambling this morning to try and figure out what exactly this bill does or does not do. So I would just register at my point my objection to this process, my objection to our feelings that we're showing as a body, to the feelings of people. If you take the original statements at face, and if this is something that 57% of people would support, I think they'd like to have a chance to see that, to see what it is that they're supporting allegedly. But that also means that 43% of the people had no input whatsoever on what this is going to look like. That saddens me as an elected official, and I would ask that going forward, we keep that in consideration, because I would be shocked if we can put together a 46-page bill in the dead of night, and that everything in that is perfect and even does what you intended it to do. And that's what the point of a deliberative body is. Thank you.
Senator Blue.
Thank you, Mr. Chairman. Let me underscore and emphasize what Minority Leader Reeves just said, but I'd like to add a couple of other things. First, I don't think anybody from my caucus was consulted on this or even asked questions about it. They may have been, I wasn't. And we haven't discussed this bill formally. But I'd make another observation. There are 17 women in the North Carolina Senate. 13 of them are Democratic women. And I don't know, it's been a long time since I had any courses relating to physiology or any of that, but I think that women are the only ones who can have an abortion. And for, of the 17, for 13 of them to have been totally ignored to bring specific perspectives to this is absolutely absurd in this, quote, deliberative body. And I'll say also that we meet every day as a caucus and discuss particular bills. Nobody had any idea yesterday in our meeting of what we might see in this committee substitute. In fact, we didn't know that a committee substitute was coming until after 4 o'clock yesterday afternoon when this bill was chosen as a vehicle. So I say I underscore what Representative Reeves said, but I too have had extensive experience in the law and interpretations of what the law is. And, you know, whoever wrote this, and I'm sure that our staff played a hand in it, could not bring the broad swath of experience that all 50 members of the Senate could bring. We had not dissected the House bill, the original abortion bill. And I just want all of you to reflect on the absurdity of the rapidity with which this bill changed and is before us today to pass it out of this committee and potentially vote on it on the Senate floor. I don't know what the plans are. Nobody has told me. I also want to underscore the fact that this is one of the most complex subjects in modern medicine. And it is something that medical experts should have weighed in on. We talk about giving Human Services, DHHS, the authority to do certain things. I don't know that there's been any meeting, certainly no public opportunity for them to express their opinion on it. And the many other groups that have had a long-standing concern and long-standing knowledge and expertise on this entire field. You know, there are doctors who specialize in this and may know of other things that ought to be considered as we prescribe what has to happen in an abortion, before an abortion, leading up to an abortion, after an abortion, and all of that. And I don't see any evidence that any of them were consulted. So I just wanted to add to the list that Representative Reeves had laid out as to why this is a poor showing of democracy, at least in a representative body. This would work well, perhaps in an autocracy or in Russia or China or some places like that. But we're in the United States, and more importantly, we're in North Carolina. And at least there ought to be an opportunity for people with opposing ideas to let those ideas compete in the marketplace of ideas. And especially when people have much greater expertise than any of us in the Senate do. I don't think, I might be wrong, but I don't think we have a medical doctor among our membership. I don't think we have a research scientist in this area among our membership in the Senate. Maybe you do in the House. But just the opportunity to fully vet all of the different concerns and all the issues related to this have been taken away from, I say, the Democrats in the Senate, which is 40%, but probably a great deal of the other senators. And more importantly, just totally ignoring what the opinions and what the contributions could be of the people who would understand better what the complications are and what the issues are, and that would include the women of the North Carolina Senate.
Senator Shedry.
Thank you, Mr. Chair. I have a series of questions that I don't know if you want to answer or staff want to answer to the points that have been made earlier. This is a 46-page bill, and I think we're trying to understand some of the provisions that have been created. I guess these are just simple yes and no questions from my perspective on whether these are adding new regulations in whether a woman would obtain an abortion. So fetal anomaly, is that a new addition to the bill?
So Senator Shedry, what the chair will do is, depending on the question, if the bill sponsors want to answer the gentleman's question, they're certainly welcome to, and if any of them who are not on the committee want to come to the podium and speak, they may, and of course staff can answer some of those questions as well. So At this point, do any of the bill sponsors want to chime in? And if not, the chair will go ahead and recognize whichever member of staff wants to answer that question.
Thank you, Mr. Chair.
Gentleman's recognized.
Jason Moran Bates, Legislative Analysis. The definition of life-limiting anomaly is new language. It is not in current existing statutory law.
Thank you. Are there new additions for informed consent for women?
Jason Moran Bates, Legislative Analysis. Yes, there are new additions for informed consent for women. Many of the existing definitions have carried over. There are some new additions added. That's for the surgical abortion, which is amending an existing statute. All of the provisions for medical abortion are new language, but they are based largely on the existing words.
And I believe you've answered my follow-up question, which is there does appear to be additional regulation as far as informed consent for surgical abortion too, correct?
Yes, that would, yes.
Are there, follow-up, Mr. Chair?
Gentleman's recognized.
Thank you. New civil fines against physicians, is that a new regulation?
The provisions that allow the boards to take action against physicians who violate the provisions of the Article 1I now are a new law, yes.
And follow-up, Mr. Chair?
Gentleman has the floor.
Thank you. So new disciplinary actions by the medical board against physicians, that's a new regulation also, correct?
It is new law in this part of Chapter 90. I believe there's an existing provision in Article 1 of Chapter 90 that does allow the board to take actions against physicians who provide abortions contrary to state law.
Gentleman's recognized.
Thank you. Civil fines against doctors, that's a new addition in regulation too, correct?
Yes, that is.
Declaration from physicians that's required, that's a new regulation?
There are reporting requirements, but I believe signing the forms is a new provision of law. Give me 1 second just to check and confirm that, though.
And if you're looking at declarations, the other question is, I guess, declaration and signatures from women who want to obtain abortions. I believe that appears to be new as well.
The informed consent provisions are actually in existing law. And let me see if there's a specific signature requirement on there. I believe the signature requirements are new.
Gentleman
Creation,
continues to have the floor.
thank you. Creation of new state printed materials.
There are existing printed materials out there. This creates some additional new ones.
Thank you. Diagnostic tests that women have to take, including for iron hemoglobin tests, that looks like that appears to be new regulations as it relates to medication that apply to abortions.
Yes, all the provisions for medical abortions would be new provisions because there is not that distinction in current law.
Verification about the gestational age of the unborn child is no more than 70 days. That appears to be a new regulation. Is that correct?
Correct. All the new regulations for medical abortions are new language.
Requiring a woman to schedule a follow-up appointment with their physician.
I believe it requires the physician to schedule the appointment, but yes, that is a new requirement.
Advertising regulations appear to be new. Is that correct?
If you're speaking of the new criminal provisions for advertising abortion drugs, yes, those are new provisions.
Licensing requirements, those appear to be new too.
Right now, they are certification requirements. This is creating licensing requirements.
Thank you. Mr. Chair, may I make a comment?
Gentleman's recognized.
Thank you. This bill is titled "The Care for Women and Children and Families," but I think from my perspective, this is false and deceptive advertising. We just listened to staff this morning spend 10 minutes summarizing a 46-page bill that's designed to govern what, when, how, where, and why a woman should get an abortion. And I got to be honest with you, as I listened to the bill summary, I was wondering why you didn't allocate money for women to hire a lawyer to help navigate through all these new laws y'all have put in place. This bill purports to allow an abortion during the first 12 weeks, but this body has put in place a 46-page bill of government red tape that requires in-person doctor visits, prohibition against abortion medications, waiting periods, bureaucratic forms, declarations from physicians, declarations from women, blood tests, fines against doctors, determining fetal anomalies that in the end all constitute unreasonable and extreme restrictions on a woman's access to abortion. And I think that these 46 pages stand as a single best example of government overreach and red tape designed to make it as difficult as possible for a woman to get an abortion in our state. Thank you, Mr. Chair.
Members, the chair momentarily is going to move to public comment. Are there other members at this point seeking discussion or debate? And the chair will come back to discussion or debate after public comment. Senator Mayfield, ladies recognized.
Recognized to speak now.
You're recognized to speak now.
Thank you. Thank you. I do have a series of questions, but I'll just, in the interest of time, make a comment at this point. You know, the way that this bill is being framed is as increasing and creating options for women. And I think that I have a couple of thoughts about that. The first is that it's an insult to women. 64% of women who have abortions in this state already have children. I think they know what their options are when they are pregnant and trying to decide what to do with their lives. The second thought I have is, as Senator Chaudhry just alluded to, more options, even if that is true, is irrelevant if access to these options is so restrictive that the options are out of reach for most people. And by requiring the in-person consultation, which currently can be done over the phone and has been done over the phone tens of thousands of times in this state, by requiring that to be in person and to require the follow-up visit for a medical abortion, this effectively bans abortion for most working women and certainly all of the women who are coming into North Carolina from out of state. We are, in fact, this bill does, in fact, reduce options that are now available to women and prevent them from making the best decisions for themselves and their families, and from implementing those decisions in the way that they would like. I would encourage us to stop trying to protect women who do not need protection in these instances, and instead trusting those women and their doctors to make the best decisions for the woman, again, and her family. I do have a couple of questions. If the
Ladies
chair-
recognized for a couple of questions.
Thank you. So the bill, well, first question is, does this bill change the definition of where abortions can be performed? And a subset of that is, if a clinic is an acceptable and is a legally acceptable place to receive an abortion now, will that also be true going forward under this bill, or does that definition change?
And the chair will ask if any members desire to answer that question, and if not, the chair will go to staff to answer that question. The gentleman's recognized.
Jason Moran Bates, Legislative Analysis. So the provisions licensing abortion clinics are entirely new. There is a process right now where DHHS can, in administrative rule, certify places for abortion clinics, but the licensure language is new. I hope that answers the question. I can clarify if it doesn't.
Follow-up.
Ladies recognized.
Do we have any estimation of the number of clinics that are currently operating that would be impacted by this? In other words, the number of clinics where women can currently access abortions, how many of those would be impacted or closed?
Gentleman's recognized.
Jason Moran Bates, Legislative Analysis. I apologize, I do not have that information.
Follow-up.
Ladies recognized.
The bill says that abortions after 12 weeks can only be performed in hospitals, and I'm wondering if there is a medically justifiable reason for that. Again, given the thousands and perhaps tens of thousands of abortions that have occurred after 12 weeks in North Carolina outside of hospitals over the last 50 years.
The chair sees Representative Baker seeking recognition. The lady want to be recognized as to this series of questions.
Yes, Mr. Chair.
The lady's recognized.
Thank you, Mr. Chair, and thank you, Senator Mayfield. I just want to address a couple of your questions. I guess the most recent one regarding requirements of in-hospital care are simply to take care of mothers. And I think one of the things that ties into another question I wanted to address. It is actually longstanding North Carolina law around chemical abortions that those be performed in the presence of a physician. And let me explain why. And you'll see this bill includes ectopic pregnancy as not being an elective abortion, and clarifying that. There are a lot of questions around ectopic pregnancies, which of course are pregnancies that don't occur in the womb, don't occur in the uterus, and therefore cannot be brought to viable life and are dangerous for the mother. So what happens is if a woman simply gets a pregnancy test on her own, that pregnancy test will confirm a pregnancy. It does not confirm an intrauterine pregnancy. If that woman who has confirmed pregnancy not through a physician's confirmation goes ahead and uses a chemical abortion pill and she has an ectopic pregnancy, she may and has bled to death. The problem is that the complications of the chemical pregnancy of mifepristone are both cramping and bleeding. So when a woman who has an ectopic pregnancy takes that chemical outside a physician's confirmed intrauterine pregnancy, when she is at home taking that medication by herself and she begins cramping and bleeding, she understandably believes that is a normal side effect. She does not know, would not know, could not know when that becomes a serious medical consequence that can lead to both her death and of course, the ejection of the ectopic pregnancy. So those are some of the reasons. Number one, again, in North Carolina, we have always required physician presence for administration of mifepristone. So the patient visits the doctor and then comes back 3 days later to take the mifepristone in the presence of the doctor, again, because we've confirmed an intrauterine pregnancy. That already exists and it is codified explicitly here. But that ties into the reason that as we've looked at this and looked at the risk to women, we would like that, we feel that it is in the best interest of the woman to have abortions, elective abortions, post 12 weeks occur in the hospital.
Senator Mayfield.
Follow up, thank you. I would be, I don't know if anyone has this, maybe we don't need it now, but I would be curious to know the percentage of abortions that happen after 12 weeks currently that are, that involve ectopic pregnancies. That would seem to be small, I would guess, and not likely a complete justification for this. But I do want to ask a clarifying question based on that answer, and that is, so it is current law that a woman has to take mifepristone in the presence of a physician, and that is also in this bill. Does this bill also require administration of the second pill in a medical abortion to be done in the presence of a physician?
Representative Baker.
I'll defer to staff to clarify the language. Thank you.
Gentleman's recognized.
Jason Moran, Bates Legislative Analysis. The bill specifies that when the drug is first administered, it has to be done in the physical presence of a physician.
Okay, all right, thank you very much.
Does the lady continue to seek recognition?
I will yield.
Okay. Members, is there any further discussion or debate at this point before we go to public comment? Okay, seeing none, we're going to move into public comment. The chair has several members of the public signed up to speak. We're going to do a minute and a half for each member of the public who has signed up to speak. If you will, when I call your name, approach the podium in the middle, in the back where the Sergeant at Arms is standing, and if you will, tell us your name, and if you're here on behalf of someone or some entity, state who you're here on behalf of. With that said, we'll begin with Jenna Beckham. If you will approach the microphone, the sergeant at arm will keep the time a minute and a half for each speaker. The lady will be recognized whenever she is ready.
Good morning, thank you. My name is Jenna Beckham. I am a physician, a board-certified obstetrician, gynecologist, and I'm a woman. So I am here on behalf of the practice of OBGYN and for the women of North Carolina and all of the people that will be negatively impacted by this bill. This bill, which has been promoted as common sense and reasonable, is anything but. This bill that is promoted as pro-woman does not support or protect women or families. This bill and these restrictions are nothing but harmful to patients and strips away their abilities to make informed, independent decisions with the support and guidance of expertly trained medical professionals like myself and my colleagues who are here today. And we should be guiding these decisions, not politicians. The requirements proposed in this bill are not evidence-based or in any way beneficial to patients, but rather create further barriers and hoops for patients and providers alike to have to jump through in order to provide care for our patients, the care that they deserve and that only we together with our patients know is best. Requirements like in-person consent, unnecessary follow-up appointments, and extra documentation and reporting are only going to take doctors away from providing actual medical care to patients. It is going to require us to exert time and energy towards administrative tasks and energy towards ensuring that we are working within the extreme legal confines of these restrictions. These restrictions are, in fact, governmental overreach into the practice of medicine. We went to medical school and completed years of rigorous training to do our jobs caring for our patients. Please let us do our jobs.
Thank you. Dr. Susan Bain.
Good morning. My name is Dr. Susan Bain. I'm a board-certified obstetrician and gynecologist. I have practiced medicine in Eastern North Carolina for 25 years. I taught medical students and residents at the Brody School of Medicine. I'm currently the medical director at a pregnancy center. I support this bill because as obstetricians and gynecologists, we care for two patients, a maternal and a fetal patient. There is never a place in medicine for the direct and intentional killing of another human being. Yes, our care at times may include the unforeseen consequence of the death of our fetal patients, but that is completely different from induced abortion. Intention of our interventions matter. This is supported by data in which 76 to 93% of practicing OBGYNs, both in academic and private practice, do not perform induced abortions. We have had essentially 50 years of unfettered access to abortion in the United States, yet our most recent maternal mortality statistics place the United States as the worst in the developed world. Abortion does not improve maternal mortality. Our patients deserve real solutions, not more abortions. Lastly, in my current practice, I only see women with unintended pregnancies. They're often alone, scared, and coerced. They deserve to be empowered with information before making a decision of such massive consequence. Informed consent is an ethical obligation of doctors, and this bill addresses that. Women also deserve. That's it, ma'am. Thank you. Thank you for your support.
Thank you. Tammy Fitzgerald.
Good morning, members of the committees. I'm Tammy Fitzgerald, Executive Director of NC Values. This bill is a step in the right direction for unborn babies and their mothers. For the first time in 50 years, North Carolina is moving towards making this state a destination for life instead of a destination for abortion. We applaud the legislators who have worked so hard to reach this compromise bill. The North Carolina Values Coalition believes that life begins at conception, and we therefore oppose abortion. This bill moves North Carolina in that direction, decreasing the gestational limit on abortion from 20 to 12 weeks. It also places very reasonable safety measures on chemical abortions. And we approve of these measures because these protect women. These are women-forward measures. And so we applaud the bill, and we thank you for bringing it to the legislature, and we support the bill. Thank you so much.
Courtney Gills.
Hello, excuse me. Hello, my name is Courtney Gills. I'm with the North Carolina Values Coalition, and I've also been a registered nurse for 10 years. I'm also currently 21 weeks pregnant. I stand in support of SB 20. This bill is a significant compromise in the pro-life community, but it is an excellent step in the right direction to protect the life, liberty, and pursuit of happiness for the mother and the baby. This bill has met the opposition of the pro-choice community for every argument in support of elective abortion except one. This bill includes exceptions for rape, incest, life of the mother, and life-limiting fetal anomalies. It provides significant funds to cover for care for unplanned pregnancy and resources for the mother and child after it's born. It makes the adoption process easier and more affordable. So which argument in support of elective abortion does this bill not combat? The argument for pure, unrestricted choice. This bill is giving the mother that choice to terminate her healthy child at or before 12 weeks, which is 3 months. That is plenty of time for a woman to test and know she's pregnant and to make that choice early. This is a picture of my personal ultrasound of my son at 13 weeks, 2 months ago. He is clearly not a lump of cells. You can see the shape of the head, nose, eyes, mouth, brain, and heart. Under current law, my little baby could have been aborted for no reason other than my personal convenience. This has to stop. I will always stand with the vulnerable who can't defend themselves, and I encourage you to do the same. Thank you.
Jeff Wright. Do we have Jeff Wright? Dr. Marty McCaffrey. The gentleman will be recognized.
My name is Marty McCaffrey. I'm a professor of pediatrics, neonatologist at UNC School of Medicine, and I'm here speaking for myself and as a medical advisor for organizations supporting parents of infants diagnosed with life-limiting disorders. This bill allows exceptions for abortion up to 24 weeks for infants with these anomalies. I wish this bill would save more mothers and infants from abortion, but it may save many. It recognizes proper terminology and addresses the lack of informed consent, which has been standard for many families dealing with these diagnoses, which some still refer to as lethal. There's no agreed medical consensus on newborn conditions that are lethal. Review of outcomes for these conditions designated lethal reveals that in all, prolonged survival is possible. Parents of these babies deserve more than an abortion referral. They should non-directively be offered options for continuation of the pregnancy. The major life-limiting disorders are trisomy 13, 18, and anencephaly. A survey of trisomy 13, 18 families found 93% were told their child's condition was lethal, 61 felt pressure to abort. That many doctors still refer to these conditions as lethal speaks volumes. For anencephaly, mothers who continue pregnancies have better mental health outcomes compared to those abort, and in a second survey, anencephalic pregnancies continued. All mothers stated they had no regrets in continuing. This legislation recognizes the need for parents to be fully informed of all options before aborting a baby with a life-limiting disorder. It is hoped and likely parents will be given the opportunity.
And this, thank you, sir. And the chair will just direct Sergeant Dorms that the chair will stop the speakers. I mean, the chair will be a little bit liberal in the time, but the chair will ask members to wrap it up around 1:30. So if you will, just keep the microphone on. Jeff Wright, I think the gentleman was outside the room when the chair called his name. The gentleman will be recognized.
Hi, I'm Jeff Wright. I'm a maternal fetal medicine doctor from Wilmington, North Carolina. I've been practicing in North Carolina since 1990, and what I do for a living is fetal diagnosis and the management of high-risk pregnancies. I just come to simply support this bill, not as eloquently as Dr. McCaffrey, but to say two things primarily. Number one, that this bill actually expands the time limit for the termination of pregnancy for fetuses with anomalies that might be called life-limiting or lethal. So it actually allows more time for those of us in the fetal diagnosis world to make a diagnosis and arrive at a firm diagnosis without the time pressure that we used to have with the 20-week cutoff. So it actually expands that. And then secondly, I would say that the bill adequately and appropriately defines what a medical emergency is and allows physicians, the actual obstetrician who was there at the time, to determine whether there is in fact, a medical emergency that warrants ending the pregnancy. It's very difficult to make a list of everything that one might need to come across, but the definition that the legislature has put in this bill is certainly adequate and appropriate for the practice of medicine, and I do not believe it interferes with those of us who need to make those difficult decisions when treating high-risk pregnancies.
Sebastian King.
Sebastian King, NC Values Coalition. Thank you, committee. We support this bill, but I really wanted to share my own personal story with you and dispel a rumor that a mother who chooses life, her life is over. When my mom was 15 years old, she got pregnant with me. She was in and out of state custody, and every single leading person in her life said your life would be over if you had this child. And that just wasn't the case. My mom worked hard to redefine our story. She invested in me, and she sacrificed tremendously for herself. But her life was not over because she had me. We redefined our family story. I became the first in my family to graduate high school. I became the first in my family to graduate college. I've started a successful business, and my mom's very successful herself. We have lived the American dream. We have to dispel the rumor that your life is over if you have your child. There is nothing more anti-woman or anti-child than to say that. This legislature invests in critical infrastructure to help women choose life and to help women have opportunity. Our state is the best state for business, and with this bill, our state will become the best state for opportunities for families in North Carolina, opportunities for children in North Carolina, and opportunity for women in North Carolina. Thank you for this bill.
Abby Schultz. Chair apologizes if I'm pronouncing that wrong, but it's difficult to read. The lady's recognized.
Hi, I'm Abby Schultz. I'm a doctor and an OBGYN in North Carolina. I provide full spectrum obstetric and gynecologic care, including abortions. I live in North Carolina, and so does my extended family, and I am dedicated to this wonderful state of ours. I appreciate that you all thought long and hard about this bill. However, I beg that you consider the safety of women of North Carolina and do not vote for this bill. I have read the bill, and I can tell you that I see patients every day that are not protected by this bill. The 15-year-old who has unstable housing, who can't make an in-person visit to be consented. Or the patient who has 4 kids already, who's the 1% whose birth control failed and can't get childcare to be seen in person for her consent or for her medically unnecessary medication abortion follow-up. What do I say to the 17-year-old who thought she was 11 weeks and then is measuring 13? I'm sorry, I can't provide your abortion, even if that means that you may have to delay college to birth your baby that you don't want to have. Many of the specifications of this bill are not in line with the current and medical research and put undue burden on our patients. I am also worried about the physicians not deciding to come to this state or leaving this state because of the law. I know many doctors who will leave. I appreciate and celebrate the changes to expand prenatal care, but who will provide this care when providers leave? There are long waiting lists for obstetricians for prenatal care, delaying care that is needed. Also, if we have to spend our time doing unnecessary in-person consents and medication abortion follow-ups, okay.
The lady may wrap up her comments.
Thank you. Who will be doing the obstetric care when we are doing all of these medically unnecessary in-person visits. Pregnancy is not health neutral, and even though we gave exceptions in this law for the risk of maternal life, I have seen this confusion result in death and severe disability of women in our state and in other states nearby who have more restrictive laws.
Thank you, ma'am. Thank you. Members, we'll move now to John Rustin.
Thank you, Mr. Chairman, members of the committee. I'm John Rustin, president of the North Carolina Family Policy Council. Quite honestly, this bill is not what we had hoped for. It's not what we had prayed for. But we do ask you to support the conference report for Senate Bill 20. The reality is that this bill is a significant improvement over our current law. It will save thousands of lives every year. It will provide critical support to women and families facing unplanned and crisis pregnancies. It will help to ensure that women are fully informed about abortion procedures and alternatives to abortion, especially with respect to chemical abortions. It will provide $160 million, as you have heard, of appropriations to improve and support adoption, foster care, child care, and other vital services. For these reasons, we ask that you support Senate Bill 20, the Care for Women, Children, and Families Act. Thank you.
Dr. Marty McCaffrey. Okay. Chair, I apologize. The gentleman had Mr. McCaffrey twice on here. Dr. Liz Thomason.
Hello, thank you for having me today. My name is Dr. Liz Thomason, and I'm a board-certified OBGYN. I offer the full breadth of OBGYN services, from delivering babies to hysterectomies, and abortion care is a part of my practice. I oppose any law that imposes restrictions on my ability to offer patient-centered, evidence-based care. I'd like to tell you about a patient of mine. She was 28 years old when she got the devastating diagnosis of a very aggressive breast cancer. She's a mom of two. She went to get her cancer care, her chemotherapy. Her cancer doctors told her to stop birth control. Her period stopped. After chemotherapy, she transitioned to radiation treatments. Her period started coming back, but sporadically. It was not surprising that she didn't know she was pregnant until 12 weeks. She immediately sought care from her cancer doctors, high-risk OB doctors, and she had two options. She could continue the pregnancy, she could stop her treatment, and when, not if, when her cancer came back, it would be incurable. Or she could have an abortion, continue her care, and have a chance at curing her cancer. In this bill, she's not sick enough to have an abortion. I took the honor of taking care of her and allowing her to choose what she needed best with her doctor's decisions and with her family's decision, what was best for her. Please let us take care of our patients the best way we know how. Thank you.
Charlotte Driscoll.
Hello, my name is Charlotte Driscoll. I'm not really representing anyone, just, a regular girl who's lived in North Carolina their entire life. My main point is here, I'm going to say first, is that abortion is complicated and can't be legislated like this. And I'm going to start by saying my story, and I'm going to speak quickly. I have bipolar disorder, and I've been dealing with suicidal ideation for 13 years. I finally found a medication that works for me called lamotrigine, but unfortunately, it makes birth control ineffective, and birth control makes lamotrigine ineffective. On top of that, I have a unicornuate uterus, which means I do not qualify for an IUD, and I can't get sterilized because no doctor will sterilize me as an unmarried 26-year-old woman. So my only option for birth control is condoms, which have an 87% effective rate. If we apply that statistic to North Carolina women of childbearing age, that's 300,000 women who would be forced to carry to term if they just use condoms as a perfectly acceptable form of birth control. On top of all that, I have PCOS that affects 1 in 10 women, and I don't get a period every month. I don't get a period every 3 months. I could easily find out that I'm pregnant outside of that 12-week window. And to be honest with you, if I found out I was pregnant at my lowest, I would kill myself. I don't want to be inflammatory, that's just the truth. But I'll end with this. The Founding Fathers included 3 words in the Declaration of Independence when they rose up against a tyrannical government who controlled them. Those words were life, liberty, and the pursuit of happiness. They included those 3 words for a reason, and this bill is infringing my right to liberty, my right to the pursuit of happiness, and we should respect what the Founding Fathers wrote. This bill does not respect that.
Kelsey McLean.
Hi, my name is Kelsey McLean. I'm a constituent from Lee County, and I'm a coordinator and clinic escort with the Triangle Abortion Access Coalition. And I'm here to bring a voice into the room that has been completely absent. You've been speaking on behalf of us, but the people who have abortions. I have had abortions. I do not regret those choices. I am thankful for those choices. And there isn't a single sponsor of this bill that I felt it appropriate or even necessary to contact and ask their opinions, their thoughts, or their views on my choices. I want to lift up that we were only given 11 hours to read, understand, and prepare for a response to this bill. This isn't a state that forced me to wait 3 days to access abortion care under some of your watch. When I needed an abortion for the first time, I underwent a waiting process of my own creation. I didn't need the state to intervene. I took my time to consider what I needed, what I wanted, and I knew I was going to be a child-free person. I knew that children were not in my future. Abortion was my only option. It wasn't because I felt that was my only option. It was my only option. I then had to undergo an even longer wait period of 2 weeks while I struggled to get the funds together for my procedure. What this bill does will force people in similar circumstances to wait longer and longer. You are not saving lives. You are not preventing abortions. You are forcing your constituents to travel out of state, endure insane restrictions, extreme costs, all to access care that they will inevitably receive regardless of where it happens. This is what you're doing to your constituents. This is your shame. Thank you.
Jerry Schill.
Thank you, Mr. Chairman and members of the committee. I'm Jerry Schill from New Bern, speaking on behalf of the God and Country Christian Alliance. My wife and I have been active in the anti-abortion crusade since 1970. That's before Roe v. Wade. Over 50 years we've been dealing with this issue, praying about it, and being active in it. If one believes that life begins at conception and abortion kills a child, there's really only one way to go, or should go, and that is a conception bill, which we have advocated. However, whatever we can do to save more babies is what we need to do. I'm speaking strictly on the issue of abortion in this bill. All the other stuff, it would take me a week at least to go through it, and another week maybe to comprehend it. But as far as the abortion restrictions, if this is the best we can do, we certainly need to do it. On the other stuff, when it comes to issues of birth control, my wife and I have been married for well over 50 years. Discipline, it works. My wife and I are very good at it. It's discipline. Need to try it. Thank you.
Jillian Riley.
Jillian Riley, Planned Parenthood South Atlantic.
For almost 50 years, North Carolinians have had the freedom to make one of life's most important decisions: if, when, and how to start a family. Now, extreme anti-abortion politicians have created a monster by pushing new restrictions that aim to shut down abortion clinics. Currently, we do not have any facilities that meet all ASC standards. This is a monster abortion ban, cloaked in medical misinformation, misdirected, and straight-up lies. In practice, it will ban abortion after 10 weeks and impose significant and, in many circumstances, insurmountable barriers on people trying to access abortion early in pregnancy. These burdens will fall hardest on people of color, on working class, on poor, on people in rural parts of the state, and people who already lack access to affordable health care. Abortion is health care, and the majority of North Carolinians agree that politicians should leave this alone and keep the law as it is. Be assured, the people of North Carolina are taking witness. We are watching, we are listening. We do not want another ban, and we will take note of who votes to restrict access to abortion.
Liz Barber.
Liz Barber, Senior Policy Counsel for the ACLU of North Carolina. This bill is anti-woman, it is anti-child, it is anti-family, it is not moderate, it does not help women choose. It's quite the opposite. It is not based on best medical practice, as any of these 24 or so doctors behind me would tell you. It is not, in fact, mainstream around the world. It is a power grab over our bodies, and it is a further attack on healthcare in North Carolina. All medical procedures require informed consent, doesn't matter what it is. How many of the thousands of medical procedures do you all, politicians, dictate what it should say? 1, abortion. How many do you all say it has to be in person? 1, abortion. Do you have to go in person for a vasectomy, an organ transplant? No, you do not. For taking medical abortion, and let's be clear, that is swallowing a pill. Swallowing a pill. A doctor, an MD, who has gone to 4 years of medical school, I don't know how many years of residency, has to witness you swallow that pill. Do they have to witness you swallow any other pills? No, of course not. It's ridiculous. So many medical procedures that are so dangerous. Organ transplants, heart surgery, I don't know. They could tell you. Do you all mandate by statute that there's a follow-up appointment? Of course not, because you're not doctors. So why are you doing it here? For a safe medical procedure. We see this for what it is. It is not just a 12-week ban, which would be bad enough, but it is an attempt to ban abortion, to take control of our bodies. It is a power grab. I urge you to vote no.
Jill Hagee. And again, the chair apologizes if the chair has that wrong. Please recognize.
Hi, my name is Jill Hagee. I'm an OBGYN in Durham County. I provide the full spectrum of reproductive health care, including obstetric services, gynecology, and abortion care. I've been a provider in the state for many years and have a strong commitment to serving the women of North Carolina. This bill restricts access to life-saving abortion services and decisions that should be made in the safety of an exam room between a person and her provider. I see every day the multitude of barriers that my patients face in accessing services that by the time they make it to me, they are often outside of the narrow window of time that is dictated by this bill. Finding transportation, childcare, funding for an abortion procedure can all take time that women would no longer have with this bill in place. These barriers will be exacerbated by new restrictions, providing 72-hour consent in person, mandated follow-ups, as well as necessitating in-hospital care for abortions over 12 weeks. Most of my patients simply can't make this a reality, and this will disproportionately affect women of color and low-income women in our state. Women with anomalies and maternal health conditions would have to jump through multiple additional hoops to access this life-saving treatment. While this bill allows for exceptions, my patients don't always fit into these exceptions and these narrow boxes. Even now, physicians are worried about the legal repercussions of providing needed care because of the current political climate. How sick does a woman have to be with a septic miscarriage or bleeding in the setting of pre-viable labor before it qualifies as a medical emergency so we can step in and use our skills that we have worked for years to honor our Hippocratic oath? You all see the number of physicians here today because we are all imploring you to stay out of our exam rooms and allow our patients the care they deserve. Thank you.
Jessica, and I can't read the last name, it starts with the name. Jessica, if you will, and that chair apologizes. The lady's recognized.
Good morning, and the last name is Morse. I apologize for the doctor handwriting. As I said, my name is Jessica Morse. I'm a native North Carolinian. I got my medical training in this state. I am a woman, I'm a mom, and I continue to live here, and my family is here. I strongly encourage you to oppose this bill. As a physician, I'm here today to advocate on behalf of my patients and my profession. As a physician, I am a compassionate person of science, and this bill lacks compassion and it lacks science. And compassion might be subjective, but science isn't. And there's so much in this bill that is not accurate and is not evidence-based. We have decades of evidence showing us that abortion is safe. Abortion is actually safer than delivering a baby. So any argument to say that this makes things safer is patently false. There is no evidence in the medical literature to support that a follow-up visit after a medication abortion improves safety. It's simply not necessary. There's no evidence in the medical literature that doing a waiting period supports safety. It certainly doesn't support compassion. So I encourage you to hear the voices of science and physicians when you think about this bill, and also hear the compassion needed to safely care for patients. We do our jobs. You have granted us that right and that privilege. Please stay out of our exam rooms and let us do our jobs. Thank you.
The last speaker the chair has signed up is Erica Pettigrew.
Good morning. My name is Dr. Erica Pettigrew. I'm a family medicine, board-certified family medicine physician, and I'm also board-certified in preventive medicine. I do primary care, and I do public health. I am not here on behalf of any organization, but I'm here to strongly urge you to vote no on this bill. I did stay up till 2 a.m. and read through the whole thing. I have notes in the margins. I could spend a long time explaining how a lot of this is medically inaccurate, medically unnecessary, dangerous. We can also look to surrounding states where they implemented simpler things, and we are now seeing the terrible consequences of that. But I just want to point out, if you look around, you see all these white coats. It is really hard to get a bunch of doctors here on such short notice, but all of the white coats sitting here are against this bill. And even though I could go into the details on why this bill is bad, instead I'm just going to take my last 30 seconds to say, you don't see the North Carolina Medical Society supporting this bill. You don't see the North Carolina OBGYN Society supporting this bill. You don't see the North Carolina Academy of Family Physicians supporting this bill. You don't see public health organizations in our state supporting this bill. There's a reason for that. And we have 1,400 medical professionals across the state that have signed that they do not want these legislative bans in North Carolina. So please respect the medical profession, vote no on this bill. Thank you.
Members, those are all the members of the public chair has signed up to speak. Is there further discussion or debate from committee members? Representative Reese.
There's some question, Mr. Chair. But before I think a lot of members are going to decide whether or not they're going to debate further. My question is, are we going to have debate on the floor?
Yes, there will be debate on the floor.
All right.
Senator Waddell.
Thank you, Mr. Chair. I've listened and been kind of quiet because I just saw this information, but while sitting here, I've received about 10 emails. And my question concerning these is, why are we anti-women? Why are we anti-child? But the main question is from several students, why are we putting this in our curriculum in the schools? Section 10 states that a charter school shall meet the same health and safety requirements. It also states that to ensure that certain students receive information annually on lawfully abandoned newborn. And it seems to be kind of frightening to students. So why are we putting this in schools if we're talking about care and protection?
And the chair will direct if there are any members on the conference committee who would like to speak to the bill, they certainly may. And if not, the chair will direct staff to speak to the lady's question to the extent staff can speak to that provision. The gentleman will be recognized.
Jason Moran Bates, Legislative Analysis. Those provisions are in the safe surrender of infants part of the bill. I can't speak as to why the policy decision was made to put them in there, but they deal with the safe surrender of infants.
Okay, it talks really related to curriculum and because it talks about the Department of Public Instruction's the grounds that parents have and charter schools giving information to those who are in homeschools. So why are we doing this? And who's going to be writing this curriculum?
And again, the chair will again ask staff if you can answer the question about who would be writing it. And I understand the gentleman can't answer the policy question of why it's in there, but the gentleman can answer the other part of the question potentially. The gentleman's recognized.
Jason Moran Bates, Legislative Analysis. I believe DHHS is in charge of writing those provisions.
All right. Thank you.
Yes, ma'am. Members, is there further discussion? Or Senator Lowe's, the gentleman seeking recognition. Oh, I see his light now. Gentleman's recognized.
Thank you. There was some parts in here, and I hate we don't have the time to really peruse this document. I'm a little slow in my reading, but I was concerned when I read some of it, and you talked about provisions being made for those persons that may be because of rape or incest or something of this kind. And I wanted to hear some elaboration on that, because if someone is raped and then they want to get an abortion, what is the process? Does it have to be a conviction before they can be raped? All of those kinds of things. And like I said, I couldn't read fast enough to read it this morning before this meeting.
And again, members, the same as last time, the chair would just ask members to raise their hand, because sometimes I can't see the light that's on because of the member sitting in front of you. So if any member wants to address that question, raise your hand, and if not, we'll go to staff. So the chair will recognize staff to speak to that question.
Jason Moran Bates, Legislative Analysis. The bill defines rape on page 3, lines 46 through 47 is the criminally injurious conduct in the nature of the conduct described in several rape statutes. If you look at the definition for incest, that's going to be on the previous page, page 2, lines 48 through 49. The criminally injurious conduct in the nature of the conduct described in GS 14-178. And if you go back to page 4, lines 18, it just says, after the 12th week and through the 20th week of a woman's pregnancy, when the procedure is performed by a qualified physician in a suitable facility in accordance with GS 90-21.82a, when the woman's pregnancy is the result of rape or incest. There's not a requirement of a conviction or a reporting. It's just if The conception results from the criminally injurious conduct described in those statutes.
Senator Lowe, gentlemen, continue to seek recognition.
Follow up.
Gentleman's recognized.
So that means that a woman can just say, I've been raped, and, I mean, is it that simple? Is that what you're saying?
The gentleman's recognized.
Jason Moran Bates, Legislative Analysis. The exception is allowed when the pregnancy related from the criminally injurious conduct described in the sections in Chapter 14.
Senator Lowe.
Follow up. Okay. The language you're using, I'm not a lawyer. So I use simple, basic language. Maybe try it, I'm gonna try it this way. What is the process for a woman that is raped?
Chair will recognize staff.
Jason Moran Bates, Legislative Analysis. The bill does not specifically speak to the process other than to define the terms.
And the chair actually is going to recognize Representative Art. The chair sees the gentleman's lights on. Again, the chair would ask members to also raise your hand if you can, because it's difficult for the chair to see your light being on. A lot of times the member sitting in front of you is blocking the chair's view of that, so I may have missed some of you all who wanted to speak. The chair apologizes, so just raise your hand. Representative Art, the gentleman's recognized.
In this bill, there are distinctions between the criminal prosecution of rape, which is separate and apart outside of this bill, and this bill doesn't address that. What this bill does is address when a woman who is raped or have incest can seek an abortion. Those are two different processes, and they don't cross over. A woman who is raped or incest can obtain an abortion under those circumstances up until 20 weeks.
Members, is there further discussion or debate?
Thank you.
Representative Baker, ladies recognized.
Thank you, Mr. Chair. And I would just add to that, I think the intent here is to uphold the special and protected relationship of the patient and the physician and the physician's judgment, because ultimately throughout this bill, it's incumbent upon reasonable judgment by the physician. And so there's no intent that the medical community is going to not support a statement on behalf of a patient that she has been raped or been the victim of incest.
Representative Clemens.
Thank you, Mr. Chair. And my questions and the comments are going to go along the same line of questioning. So, also not a lawyer, maybe a staff question, but can you describe if there's a woman who's 14 weeks pregnant because she was raped, what would happen for her to seek medical care?
And members, again, if there are any members of the committee who want to answer the question, the chair is going to look around and see if anyone raises their hand. Again, the chair will go to staffers and let staff answer that. If any members want to follow up with that, they can. The gentleman will be recognized.
Jason Moran Bates, Legislative Analysis. I apologize. I don't know what the medical process is for seeking abortion. I can just say that the bill, as it is written, does not require reporting or conviction. It just says that if the pregnancy is a result of rape, as defined in the bill, which just lists some criminal statutes, or incest, as defined in the bill, which just lists some criminal statutes, then abortion is permitted through the 20th week of pregnancy.
Follow up.
Ladies recognized.
And so what does the bill say will happen if there is a woman at 14 weeks? I hear what you're saying, that it doesn't have the criminal discussion in this bill. I'm asking, what would the woman go through because it is hard, as has been said when we just got this, to understand each of the sections and what is required for which type of exception. So I'm specifically asking for that exception.
Chair sees Representative Baker's lights on. The ladies recognized to answer that question.
Thank you. Thank you, Representative Clemens. So in this bill, there's absolutely no requirement for reporting to law enforcement for a woman to go to a physician and say, I've been raped, and then that physician, within the parameters of this bill, absolutely has the ability to refer for an abortion. and support her throughout.
Representative R.
An additional requirement in this bill is that abortion, since it occurs outside the 12-week permitted period, would be performed in the hospital. And the procedures would be going forward between the woman and the doctor. The location must be performed in the hospital.
Representative Clemens.
Thank you, Mr. Chair. Okay, so thank you. That was a specific difference, that it would have to be in the hospital in that case. What would the informed consent process look like in that case, in this bill?
Again, the chair will go ahead and go to staff, and if members want to address the question, we'll go to them next. Gentleman's recognized.
Jason Moran Bates, legislative analysis. If it's at 14 weeks, it would be a surgical abortion. It would be done in a hospital. The informed consent process would be at least 72 hours prior. The woman would have to sign an informed consent form, which includes the name of the physician who will provide the surgical abortion, the risks associated with the procedure, the probable gestational age of the unborn child, risks associated with carrying the child to term, display of a real-time view of the unborn child with heart tone monitoring, statement whether the physician has liability insurance, and the location of a hospital that offers obstetrical or gynecological care within 30 miles where the woman could go if there are any complications. The woman would have to sign all of that. It would also have to be signed by the physician, and there would have to be a acknowledgement of risks that goes along with that, and I can give you those items if you would like them.
Representative Clemens.
Thank you, and thank you to staff who's doing a great job with a hard task today. I'd just like to make a comment at this point, Mr.
Ladies
Chair.
recognized.
Thank you. I've been trying to pull myself together to comment on this bill today because, like many bills, I think about it for all of our state, but I mostly think about it for my own children. And I spend a lot of time with 12-year-old girls because my daughter is one. And I know the statistics that 1 out of 5 of them will be victims of an attempted or completed rape. 1 out of 5 of them. And that only 30% of them will ever report that rape because they're afraid. It might have been someone in their family. They don't know what they did wrong or why they're in this position. And I think about if one of them didn't report that because of a lot of reasons that a 14 or 15 or 17-year-old girl is trying to figure out, and then finds out she's pregnant and sits with that for weeks on her own, scared, not sure what to do, and then came to me for help. And I was in the position of telling her that she would have to go to a hospital to be taken care of, or look at an ultrasound, or if she happened to live beyond the 30-mile radius, that might be a challenge, or that she would have to go and hear all this information as a scared 15-year-old and then sit with it for 72 hours before she could have a change. I cannot support, there are lots of reasons I think this process has been wrong, but I cannot support a bill. Another member of my caucus said, I've never felt so emotional, and that's how I feel today. I cannot support a bill, and I feel at a loss for the girls that I spend my life with. And I know there are moms, good moms, on the other side of this issue. I am just saying where I am. And then I think about, what if my daughter's 25 and she has a very wanted pregnancy, but her blood pressure spikes like mine did, and it became potentially life-threatening, but maybe not quite enough. And instead of her doctor making the medical decision to help her, They're pulling out their law book or calling their attorney instead of giving her the best information. So for all of our daughters, I will be voting no, and I hope other people will consider the impact on the girls that are looking to us.
Members, is there further discussion or debate from the committee? Representative Carney, the lady's recommendation.
Thank you, Mr. Chairman. I walked in this room today, and the first thing that was said about this conference report when it was presented by a member, the first words were, "This is a very complex issue." And then we proceeded to have, my calculation was about 15 minutes from a staff person that laid out 48 pages. I go to bed early at night. So when this bill came out after 10:15, I had not read it when I woke up this morning. But my phone, my emails were blowing up. And I get emotional. I've been in here 20 years, and I have never seen, I've seen bills rush through. I have seen bills done in just a few people in a conference report and others left out. But this life-changing legislation that, number one, affects women, number two, men, but most importantly, it affects our medical profession. And I am someone who's alive today because of the medical community and because of their quick reaction to make a decision without my colleagues at the legislature having to weigh in and them checking on that legislation. Can we do this? Check, pull the lawyers in. We all know that. I'm disappointed that only a couple of the conference committee members, the conference report members, have been able to answer or have spoken up to answer questions. A couple have. But it's fallen on a staff member that is nonpartisan, which is a good thing, did an amazing job on a very complex issue. My emotions this morning are not necessarily because of the whole issue before us, but it's because of my 14 grandchildren, 8 of which are female, 1 non-binary, and my grandsons, who are faced with the consequences of their actions down the road. It's for my 6 children and their spouses, 3 daughters and 3 daughter-in-laws. Those were the emails, text message that I worked to today. And they range in the age from 3 years to 57 within my family. With everyone in there that has been impacted with the whole issue of life choosing at different levels. So we have experienced all of this. And yet their mom, mother-in-law, grandmother, Ra-Ra, is expected to walk in a building today, in a committee room, hear a conference report that was not debated with us publicly, loaded with different sections that we have to process, and I'm expected to vote on it. For many reasons, because of the hand tying that we're doing in so many aspects. There are questions like crazy. I'm concerned about DHHS and their reporting requirements. I'm concerned when I hear things like what's required that is new. And I will add that there have been numerous bills filed individually by our side of the aisle, Democrats, that have not been taken up. But somehow, just a snippet of them are rolled into this bill. And we had no say over which snippet of a bill that we filed that never got heard made it in or why it made it in. Our leader said earlier that this has not been a democratic process. And all of you know me. In my 20 years here, I have worked both sides of the aisle. I have not been an outspoken, vocal member chastising people because I go to people and work with them. I have not had one member come to me prior to this bill dropping last night and ask me for my input. What did I think about? What are the impacts? What's good and bad? What is your input? I have a vote out of 120 on the most egregious bill that has not seen the light of day in its current form until this morning when the sun came up. I'm asking you all to please take a pause. It is unconscionable that this bill has dropped the day before crossover. I understand crossover. I understand the rush to make things happen, but it doesn't have to be. I'm begging to please step back, take a pause, and let's have a more in-depth discussion within the next 48 hours. We've got until the gavel bangs tomorrow to move this bill out. Thank you, Mr. Speaker.
Senator Sawyer.
Thank you, Mr. Chair. I want to say that I hear those of you who have communicated today that are in the loyal opposition party. I hear you feel like you haven't been heard, and I understand your frustration. Your frustration is not lost on me. And your voices, although you feel like have not been heard, they are represented. You see, just because I'm a Republican doesn't mean I disagree with some of the points that you made. It doesn't mean that your voices haven't been reflected in this bill. I hear a mischaracterization of this bill over and over again as a ban on abortion, as anti-woman, anti-democratic. But what you are is discounting the work that I've put in on this bill, that other women have put in on this bill. We've had these discussions. We know what you would have said if we came to you. You never would have voted for these bills. I am confident that this is the best piece of compromise, mainstream legislation that we could put forward. I reject the fact, what I'm hearing today, that this is anti-woman and anti-democratic. And I definitely reject the fact that your voices haven't been heard. For we heard them during the elections, we hear them today, and we'll continue to hear them when we override the veto. Thank you.
Representative Reeves, gentleman's recognized.
Thank you. And I just want to clarify a couple of points, and I don't want to get deeply in because I appreciate you, Mr. Chair, saying we'll have a chance to debate today on the floor. But I do want to be clear about one thing, because I think I brought up the anti-democratic statement. That is this process. I've not applied that to the bill. I've said that the process is that, and I'm trying to think of, because I am inarticulate at times, how to express one frustration that I have beyond what I've heard. And I'll admit that listening to Representative Clemons and Carney was difficult. because I think of all these women I've known in my life and the impossible positions they've been put in. But what I think is most problematic, if you ask me about the bill, is a statement when somebody says to me, I know what you would have done, I know what you would have said. And if I were a woman, what would be most problematic is when somebody tells me that they're protecting me, because we had a bill earlier in this session where somebody was telling me as an African American that they were doing something to help me when they didn't ask me. And that's where I struggle here, is I've not heard one woman come up and say, I need these protections because I have been put in a position where I can't do what I feel I should be able to do. So, one, when I say anti-democratic, the most anti-democratic thing you can do is ever presume, and I can't speak for everybody else, but I do think I speak for a majority of my caucus, you've got no idea what I think on this issue. And that's the truth. I can promise you not one single person out of the 170 members of this body honestly knows what I feel about this issue, honestly knows how seriously I consider this issue, honestly knows how much the issue bothers me. And I am saying that as a man. So I promise you then can't presume what a woman feels. And I think that one of the things that I caution our caucus members about is do not generalize because of a person's affiliation politically or anything of that sort, because I can promise you the one thing I don't think this should have ever been, and that genie got out of the bottle 40 years ago, this never should have been a political discussion. Because I think if there is one thing that we are terrible at, is controlling our emotions, our feelings, and our opinions about how somebody else should live their lives. And that gets into my religion and my feelings there, and it bothers me so bad how that gets factored in, because I can speak for me and I can speak for the man that sits beside me on the floor, or how seriously we take that subject. So when I say anti-democratic is looking at me and telling me, well, you know, I know what you're going to say anyway, so I'm not going to waste time getting your opinion. That is the very antithesis of a democracy, and is the very antithesis of understanding that we are all different, all separate, not a monolith, and we are all human beings who have a right to have opinions. So please keep that in mind, because we will be debating this on the floor, and I'm just hoping that doesn't come up on the floor. Thank you, Mr. Chair.
Members, is there further discussion or debate on the bill? Seeing none, Representative Perret is recognized for a motion. This, is, of course, is just for the House members. The senators can't vote on this. Representative Perret, the lady is recognized for a motion.
Yes, Mr. Chair, I move that the conference report for Senate Bill 20 be reported with a recommendation for adoption.
Members, you've heard Representative Perret's motion. All those in favor will say aye. All those opposed, no. The ayes have it, and the motion carries. Members, that is it for this committee meeting today. There being no further business before the committee is now adjourned.